The site, just ask him. No, he's here. In fact, if I can show the large property. It's a fairly double-story property. 50 into 80 feet.
15 into?
50 into 80 feet. 50 into. It's a large bungalow.
Which year?
4,000 square feet.
Constructed in which year?
1960s.
60?
Yes, 60s. Because we bought it in 60 and 64 after that. Land was
which
so it was bought, the land was bought in 60. After that, immediately in the 60s, it was constructed. 60.
In the decade of
old house. There are some photographs of the house if your lordship wants to have a look at. You can show.
Just a request, Lordship may keep this matter after 2 weeks because I filed just yesterday.
What else do you have to say apart from that? Your affidavits now on the record.
Lordship.
And if somebody's property is destroyed without any demarcation, acquisition, what is the due process which you follow? You say that you have only, Nadi, which is the beat of the drum.
Lordship.
That's not the way. People's properties have to be
permitted to seek instructions whether any notices were sent besides the Munaris.
We have affidavit. Notice was issued. You say that we only went to the site and informed people. That's all.
From 2007 to I think September.
That's all that you have said. If there was a notice, you would have said in your counter affidavit. This is what your counter affidavit by the district magistrates.
I understand, Lordship.
And
however,
properties are entitled to some.
I understand, Lordship. However, I accommodation. I do not want any.
Time because it's completely the affidavits have been filed. Because NHRC made its own subject matter of challenge. But what about the commissioners and the commissioners? The commissioner's report is not denied. For the state. The state. I mean, how can this kind of activities? What are your prayers in the?
Yes, my lord. I wanted to show them. It's rather unhappily worded. Please have a look at PDF 10 of the, because that's the petition. I hesitate to read it, but I will. If your lordships have it, I'll read it. So, this is, you are humbly requested to get a CBI inquiry. So, he wants an independent conducted against DM who has flouted human rights, inflicted severe tyranny, injustice, torture, and heavy humane physical.
This is internal page.
My lord, this is internal page. This is the last page of that. The second last page of that of the complaint. Sorry, there is no para number here. I have a copy. If your lordship wants, I can hand it over. This I have a print of, just because I need this give a print of. This we have.
Yes, Chief Secretary, Government of Uttar Pradesh.
No, my lord. It starts. Can I just hand over? My lord, it's just a few pages. I'm very sorry. Normally, I would read it from here. Your lordship would indulge me only for this. October 19 letter petition to the Secretary General of the Supreme Court. My lord, lordship would just come to the last but one page. This is his prayer. The one in bold.
Yeah. We may be inclined to award punitive compensation to your client. Serve the ends of justice.
Just one other, one other thing, your lordship may. The commissioner has also, in a sense, recommended is the departmental inquiry aspect. Some independent, of course, he mentioned CBI, but that's all right. Your lordships may have some independent. That's my, those are my only two additions.
Now, why opening whatever is concluded in your favor?
No, so very well. Let's so very. Commissioner
has to be taken.
That's what I meant. Because otherwise that report remains a dead letter.
Some
There has to
accountability.
be some. But that's fair enough. Commissioner is as far as. He's saying CBI, etc., but I'll leave it to it. Action was by malicious. Action of proceeding against him was malicious. Forget just the demolition, the way
How many houses did they demolish like that?
total से तो पूछिए. ये total कितने थे?
There were 120 illegal encroachments on, is what the counter affidavit says.
They are illegal construction. Show us what is the basis of this case
Lordship.
that all this construction was unauthorized.
बोल दिया है.
Our counter affidavit,
What is the basis for you to say that this was unauthorized?
which is why, Lordship,
What inquiry did you undertake?
if I may be just given some time,
The constructions were unauthorized. What 1960 till 2000
Lordship.
for all these years? That this is all unauthorized. In the land of your ownership, that this construction was put up on the government. Is it?
Lordship. Which is why, Lordship, I just.
Sorry. Very high-handed action. And today, if we close our eyes to the same thing will happen. We can't tolerate this.
We'll bow down to whatever your Lordship.
Here for the state, it was expected for the state to take appropriate action.
Lordship.
State show some respect to the national human orders also.
Yes, your Lordship.
You are thereby protecting an order in a very high-handed manner.
May decide.
A suo motu writ petition was registered under Article 32 of the Constitution on a letter dated 4 October 2019, addressed by Sri Manoj Tibrewal Akash, complaining of the demolition of his of an ancestral residential house and shop situated in ward number 16, house number, of his ancestral house and shop described as house 7 in ward number 16, Mohalla Hamid Nagar, district Maharajganj. Stop. Notice was issued of the writ petition after the letter was registered as a writ petition. Note de do, writ petition civil number 1294 of 2020. To the district magistrate Maharajganj, to the district magistrate of police of district Maharajganj. Full stop. In pursuance of the proceedings which have been initiated before this court, affidavit or how many?
There are
Two counts.
One are the
Sir, affidavits have been filed by the district magistrate and the superintendent of police,
Yes.
which have been followed by a rejoinder by the.
Then what do you mean? ठीक है सर, बोल दिया.
Petitioner 1975.
Milord, we had filed, there was a suit filed because there was an inter se in which there was a stay order passed of 75. We had pointed that out when we wrote to the DM, rather my mother wrote to the DM that there's a stay order, to which he said, because of Asian research was enforced at that time, that stay order was not extended, therefore I'm coming to demolish any. I didn't point it out.
Was dismissed.
94 देखा ना काउंटर का 94.
Babulal and others, Shubkaran and Sushil versus
Yes.
State of UP. What is that?
Yes,
restriction
yes.
for?
As I said, Milord, the partition proceedings between the parties. That order is at page 94 of the counter. Please have a look at that itself.
PDF. It was an interim order.
It was an interim order which says that because it's. But when we pointed this out saying that it's pending, they said that this order was not extended to the Asian resurfacing, therefore we will notice.
But the petition was dismissed, or what happened?
What is happening?
It was dismissed, Your Lordship. It was dismissed.
It was
What was the prayer in that writ petition?
Go to the president. मुझे बताइए. Okay, so he says that even at that stage in 17, it was contemplated for widening, so he went and got a stay there, which was then this thing. So,
Because Lordship,
I think I found this.
my application before the DM says that if your lordship will just look at page 92 of the same document, same file, my lord. This is the my lord. Sorry. Where is Asian resurfacing mentioned?
It was only in the state highway was pre-existing, and it was in 12 that a notification.
You know what you did, ma'am.
Not sure.
Previous night, the team must have come. They demarcated the portion which they wanted for the purpose of widening. Right? That was about 5 feet or something.
Not sure.
In accordance with that yellow marking.
Not sure.
Other people also demolished those portions with the yellow marking. After he demolished on his own volition, next day you come with bulldozers.
Yes.
Now what you did was, this marking, yellow marking was in accordance with the revenue record because the road is only of 16 feet wide, 16 feet or meters.
Meter.
So if you take the middle of it, meters on left, 8 meters on right. You ignored the revenue records. You took it as if it is 16 meters on right and on left, and you demolished everything. Then what was the idea in putting that yellow? What was the idea behind it? You did it, they demolished it. Next day morning, to their misery, the bulldozers come and they demolish. This is what.
Count 123 houses were demolished. This is one of the reasons why we are seeking an independent inquiry into. Of course, I have 123 houses in a row, which is why we've sought this.
If you, for the purpose of a genuine public project, you can do it. But then there's a procedure for it. You have to issue a notice. You have to go for their objections. It is like acquisition.
Yes,
you can't come with bulldozers and demolish the construction overnight.
Must fairly submit has not been done. So that I.
You don't give family time. What about the household articles inside the house? All this, where will they put it?
I just wanted to clarify with respect to widening that it was in the 2012, the notification.
All right, widening was just an excuse. It doesn't seem to be a genuine reason for the entire exercise.
Although the notification we have placed on Board Lordship, the 2012 notification that we have placed on annexure CA2 and 3.
And what is this Munadi?
It's announcement.
The days of Munadi are gone. Munadi is good enough for execution of a decree passed by a civil court.
Yes, Your Lordship.
You can't just on a bit of a drum tell, vacate the house, we are here to demolish it.
That I must fairly submit that.
Something like a rule of law?
Yes.
Full stop. The affidavit filed by since the petition has been registered, letter written by the petitioner, and to obviate any controversy in regard to the facts, we would proceed on the basis of the facts as are revealed in the counter affidavit filed by the district magistrate. Full stop. The affidavit discloses March 2012, the state highway commencing from district Pilibhit via Bharej, Balrampur, Maharajganj, and concluding at Padrona, was notified as National Highway 730 under the National Highways Act 1956. Prior to that notification, the road in question is stated to have been a state highway. On 13 March 2018, final DPR for widening NH 730 from KM 505.120 is stated to have been prepared right of way at the aforesaid chainage of 30 meters. That's what you have said, no? 30.
Yes, Your Lordship, 30 meters.
The Union Government of India following a sanction by the Government of India on 13 March 2018, was executed on 2 May 2018 by the State Public Works Department with a concessionaire, with Messrs. Mahakaleshwar Infratech Private Limited, bracket MIPL, for the execution of the work. The work order, it has been stipulated the commencement of work on 18 February 2019 and the date of completion as 17 February 2020. According to the district magistrate, in June 2019, it was found, after identifying the right of way, that out of the total sanctioned length of 21.120 km, about 4 kilometers of length fell in Maharajganj town. Full stop. Were identified to have encroached upon the land of NH7, including allegedly thereafter, according to the collector, an announcement, according to the collector, a announcement was made by, a Munadi announcement was made, into brackets, by beat of drums from 25 August 2019 to 30 August 2019 and from 1 September 2019 to 6 September 2019.
From June to just the sentence above it started from
Munadi announcement was made from 19 and from 25 August. Huh? On 4 July 2019, it is alleged, the mother of the petitioner made an application to the district magistrate requesting him not to demolish her house by placing reliance on an interim order dated 14 November 1975, Court of Judicature at Allahabad, in a writ petition as Babulal versus State of Uttar Pradesh. On 8 September 2019, the brother of the petitioner is stated to have furnished a letter to the authorities recording that he had purchased the house stroke land, which was registered in the revenue records under Abadi land category 6.2, semicolon, was co-owned by that the house was co-owned by 3 persons, and that in 1975 he had instituted a writ petition, and interim order was passed restraining demolition. However, the writ petition is alleged to have been destroyed. brother of the petitioner have stated that if the house was required to be demolished for construction of NH 730, compensation should be awarded. According to the collector, on the evening of 12 September 2019, the occupants of the house were called upon to remove all their belongings. 13 September 2019, into invert commas, the petitioner is alleged to have, the petitioner is stated to have instituted writ petition 1335 of 2020 before the High Court of Judicature at Allahabad on 28 September 2019. Stop. On 4 October 2019, he moved a complaint before the National Human Rights Commission, which was registered as case 074 stroke 24 stroke 2019. NHRC constituted a team of two conducting a spot inquiry for which letters were District Magistrate and Superintendent. According to the collector's affidavit, on 5 November 2019, petitioner's brother, into bracket Shubpal, bracket, filed a notarized affidavit in which he stated that there was a two ancestral house which was constructed pursuant to the purchase of the house by his late father on 6 June 1964 by a registered deed in which the deponent had a 1/3 share. According to him, a registered deed of partition had taken place in the family in November 1967. When in 1975, the PWD attempted to demolish the a petition was in the High Court in which on 14 November 1975, a division bench had passed an interim order. Since the could not be implemented, was stated to have been instituted as between the co-sharers. The writ petition which was before the High Court of Judicature at Allahabad for challenging the demolition action was withdrawn on 18 January 2020 before the division bench. The petitioner, as already noted earlier, had filed addressed a communication to this court and instituted a complaint before the NHRC.
Lordship, the brother had also given consent for demolition. It belongs to him. That may also be.
According to the collector, the brother of the petitioner had given his consent for the purpose of the demolition.
Of his share.
Of his share. Of his share, he says you can.
Anyway, way for him to get the partition, I suppose that's what. Anyway, that's not the issue here.
Next. In this backdrop, it appears from the material of the record that when the petitioner moved the NHRC, a detailed inquiry took place. Full stop. The NHRC, by its report dated, what is it?
220.
Right, 3/20. Inter alia concluded demolition. Public announcement through loudspeaker. The house of the complainant was constructed on land bought by his grandfather in the year 1960 and 1960. Semicolon, bracket. The spot inspections and measurements done by the revenue department in the presence of the NHS team revealed that the extent on government of 3.70 meters in length, and that extent because the land was falling under a 16 feet wide road.
Meters.
It's a 16 feet, so it's 16 meter wide road. 4. However, the house was demolished beyond the encroachment of 3.70 meters, and it appears, and the actual demolition was between 5 to 8 meters. No compensation has been furnished for the demolition of the property. 6. The mother of the petitioner had submitted a complaint to the DM Maharajganj and the police on 4 July 2019. The demolition action commenced on 7 2019. And on 13 September 2019, the house, which was 16 meters of the road, was demolished. Seven, provided by the government officials of NH-PWD revealed that house items as alleged by the complainant were in the house before starting the work of demolition. the findings of the NHRC indicate that at the highest, the demolition action to the extent of 3.70 meters justified on the ground of an encroachment. But there was absolutely no justification for demolition action beyond the alleged encroachment. That the government agency had failed to provide any document to support that the road width in front of the house of the petitioner was 32 meters into brackets 16-16 meters bracket from the center of the road. The revenue record and the NH-PWD records were stated to have revealed that the road width in front of the house of the petitioner was only 16 meters into brackets 8 meters from the center of the road bracket. However, the district administration and the officers removed demolished properties up to 32 meters into brackets 16-16 meters from the center of the road on both sides. Any authority of law. NHRC therefore recommends bracket 1 the issuance of a notice to the Chief Secretary for the compensation to the complainant petitioner. Bracket 2 a direction to the DGP to have an FIR registered on the complaint lodged by the petitioner administration. And 3 a direction to the Chief Secretary to take departmental / punitive action. Full stop. The first report of the NHRC was followed by a subsequent.
No, Manoj, that is 6/7/20.
2020.
2 March is the show. The report is of 6/7/20.
Right, of 6 July 2020. Along similar lines, right?
Actually, this is a final order, an interim order. It's not a report as such. This 6/7/20 is an order.
6/20 and by an order dated 6 July 2020. Full stop. Besides the full stop, the report by the NHRC has been challenged by the state of Uttar Pradesh in a writ petition High Court of Judicature at Allahabad, which is pending pursuant to the issuance of notices. Full stop. Quite apart from the report of the NHRC, the issue was investigated by the Commissioner Basti on 2 occasions. Full stop. The Commissioner Basti recorded by the Commissioner are extracted below. ये आपको page 287 after on-site inspection of records यहाँ से लेकर paragraph 7 will conclude at page 289. Following a district magistrate, the Commissioner passed a further order dated 31 July 2020. In the subsequent order, the Commissioner observed, page 292, it is clear providing the above administrative support, the then district magistrate, up to therefore the representation assertion submitted by the district magistrate Shri Amarnath Upadhyay is not acceptable at all. Next. We have heard Mr. Siddharth Bhatnagar, then senior counsel who appeared on behalf of the petitioner, and Ms. Tulika Mukherjee, learned counsel appearing on behalf of the state of Uttar Pradesh. So we are not inclined to the state of the counsel for the state for a further adjournment to these proceedings, having due regard that pleadings have been completed and the court is required to evaluate because they have been placed by the state on the record for deciding upon the legality of the action. Full stop. The narration of facts would indicate the following position emerges from the narration. The state of Uttar Pradesh has produced no document to indicate the original width of the state, which was notified as a national highway. Semicolon, bracket 2. No material has been produced on the record by the state of Uttar Pradesh to indicate whether any inquiry was carried out to earmark the encroachers, particularly with reference to any demarcation proceeding. 3. There is absolutely no material produced before this court to indicate that the land had been acquired before the work of demolition was carried out. Full stop. The affidavit, beyond stating on affidavit that there was an encroachment, the state has failed to disclose, bracket 1, the precise extent of the encroachment, semicolon, bracket 2, the width of the road, the width of the highway, the width of the existing road. 3, the width of the notice highway, semicolon, bracket 4, the extent of the property of the petitioner which actually fell within the width center line of the highway, outside from the notified width, semicolon, and bracket 4, why the demolition was required to be carried out beyond even the encroachment. As the report which has been submitted by the NHRC at least would prima facie indicate, the demolition was far in excess of even the alleged encroachment of 3.70 meters. Apart from the above, it is clear that the demolition was carried out only following a beat of only with a munadi and with no notice or opportunity, or with no notice or disclosure to occupiers of the basis of the demarcation or the extent of the demolition which was to be carried out. On the facts that as they have emerged on the basis of the disclosure by the state of Uttar Pradesh, it is clear that the demolition was completely high-handed and without the authority of law. Full stop. At this stage, it may be also material to note that the allegation of the petitioner in his letter dated 2019 to the Secretary General is in the following terms. The letter may the petitioner has therefore clearly alleged that the action for demolition was a reprisal for the report which had been published in the local newspapers in regard to allegations of wrongdoing in relation to the construction of the road. So for the purpose of these proceedings, it is not necessary for this court to enter upon this aspect, save and except to flag the grievance of the petitioner. Full stop. However, full stop. Such action by the state cannot be countenanced. Any action in respect of private property must be followed by due process of law. Full stop. Before taking action in pursuance of a road widening project, the state or its instrumentality, as the case may be, must inter alia undertake the following steps: bracket 1, ascertainment of the existing in terms of records stroke maps. 2, a survey stroke demarcation to assess if there is any encroachment on the existing road with reference to the existing records stroke maps. Bracket 3, if an encroachment is found, the issuance of a notice to the encroacher to remove the encroachment. 4, in the event that the noticee raises an objection with regard to the correctness or validity of the notice, a decision on the objection by a speaking order in due compliance with justice. 5, if the objection is rejected, a reasonable notice should be furnished to the adverse action is proposed to remove the encroachment, and upon the failure of the person concerned to do so, the competent authority or state may take action, make the encroachment. unless restrained by an order of the competent authority or court. And 6, if the existing width of road, including the state land adjoining the road, to accommodate, steps would have to be taken by the state to acquire the land in accordance with before undertaking a road widening exercise. I'll stop in the conclusion that the entire process, which was followed by the state, was high-handed. To pass 2 directions. First, a direction for the payment of punitive compensation, semicolon, a direction to the Commissioner Basti, direction to the...
It will be to the state.
To the Secretary, Public Works Department to conduct
To the Chief Secretary, I was thinking.
a direction to the Chief Secretary of the Government of Uttar Pradesh to entrust to matter to have the entire matter to have an inquiry conducted into the entire matter pertaining to the illegal demolition
Against the then DN, because now
against all officers, including contractors who may be found to be involved, who are responsible for the illegal demolition. Stop. This would include disciplinary action against any officer who is found to be involved in the demolition, not only of the house of the petitioner, situated properties in the area which were alleged to have been demolished in a similar manner.
according to them, there were 123. According to them. Go to the one.
The of Uttar Pradesh compensation quantified at rupees. Stop. This compensation would be of an interim nature and would not come in the way of the petitioner, should he be so advised to adopt any other proceedings which are available in law for the payment of compensation.
You know, the NHRC's report your lordships have seen, it also said FIR will be registered. So that they will have nothing about. So that your lordships will observe something on that, which is at page 162 of the counter. Your lordship, sorry. Those are the three. One, FIR, then departmental, and those are the just show me 162.
The above directions shall be followed. Of the government of Uttar Pradesh will, after conducting the inquiry, take suitable action, including action of a criminal nature, where it is, including action of a criminal nature to of any individual found to be in violation of law. Full stop. The exercise to implement the implementation of these directions shall be initiated no later than within a period of 1 month from the date.
I'm deeply obliged. It's just that the direction was that DGP will get an FIR registered.
Shall circulate the direction which have been issued, that shall circulate a copy of this judgment. Secretaries of all states, stroke duties,
Yes.
To ensure compliance with the with regard to the procedure to be followed for the purpose of road widening.
So I'm deeply grateful. Not just one issue, whether your lordships would like to consider saying something about the pending writ, whether it should be heard, decided, etc. Because there the question will be of the DGP challenge there and so. So let
the High Court, whenever the High Court will deal, rightfully deal. We have gone, therefore we have said that we are not going by the entirely by the NHRC, we have gone by the record which is before us.
Absolutely. I was
Said that it is completely high-handed and we have awarded punitive compensation and we have said departmental action, inquiry by the Chief Secretary of the State of Uttar Pradesh.
I'm very grateful to you.
Anything else?
Very grateful. You also spent a lot of time on this matter. Deeply.
Because we wanted to formulate broader, I got a lot of assistance from my two colleagues
No,
on the broader directions, you know.
Obliged much.
My lords. My lords, it is against gender discriminatory provision. My lords.
This is item 2.
My lords.
Shweta Gupta versus Union of
Gender
India.
discriminatory provisions, my lords.
Sorry?
It is against provisions based on marital status
Now
of
this,
women.
you'll have to keep it some other, keep it after 4 weeks.
My lord, may issue notices, my It's
item 2.
Item 2, my
It's a
lords.
fresh matter.
Fresh matter, my lords.
This for what? UP, what are you challenging?
UP and Uttarakhand, my lord. The laws are gender discriminatory. When a daughter marries,
we already had that petition under the Hindu Succession Act.
my lords.
Poker versus Union of India, which is post notice.
My lords.
If you want to if you want to intervene in that, you can in that.
Because these provisions are quite wide. They are more discriminatory than merely Section 15 of the Hindu Succession Act. Because here they say that if a daughter marries, divested of her interest in the land. If a widow remarries, she also loses her interest in the land. Provisions are quite wide and more discriminatory in nature as
Issue notice here.
Deeply obliged, my lord, deeply obliged. Item number 3, I'm also appearing, my lords. My lord, it is against the for the ensuring the compliance of Rule 18, Sub-Rule 1, Clause 2, which requires annual immovable property returns to be filed by the Group A and Group B officers. They are not of this statutory rule.
This is just one of your PILs, you know. We'll not...
my lord, just see that they have, which clearly
we don't want to monitor all this now. I mean, we will be only doing this exercise.
My lord.
Yes.
Please, Milad. Similar SLP filed by a batch of 91 students. This is an order which is at page 241.
That on deposit of 7.5 lakhs, you will get your original document.
Yes, yes, Milad.
You are in the same
batch.
Same batch.
Yes, yes, Milad.
We'll issue notice here and make it returnable in 2 weeks.
Please, Milad, the only urgency is that now will begin. They have paid the excess amount in by virtue of certain emergent occasions and situations they had to apply. The only limited direction we're asking, we'll abide by and give the undertaking.
Of our 9 September order.
We'll comply with that order and give an undertaking to the college.
Is the same college?
Same college, Milad. Same college.
In view, issue notice, returnable on, in view of the order dated 9 September 2000 by this court in Sahil Bhargav versus State of, uske upar likh lo, Ms. Tanvi Dubey, then Chancellor appearing on behalf of the submits that the present case is similar to a case which has already been entertained by this court, namely Sahil Bhargav and SLP Civil number 19953 of 2024, in which an order, right?
Yes, yes.
In which an interim order was passed on 9 September 2024. Next. In view of the interim order dated 9 September 2024, following order. Then we'll just copy the order.
Yes.
So 7.5 lakhs you will have to deposit with the college, give an undertaking, and then on that condition you will get your document.
Yes, Manoj. In fact,
The order which we are, with the operative order which we have passed is comprehensive. So that
yes, yes, Manoj. Great.
That's in item 5. There is no impugned order yet. But what we put was the order at page 206, Annexure P9. Can I draw your lordship's attention to order at page 206, which is the DRAT's order?
which said that you should deposit 13 crores.
13 crores. The problem is this. The DRT proceedings there were two parts of the DRT order, Manoj. One allowing my counterclaim to an extent of 4 crores, and one allowing the bank's recovery proceedings to an extent of 8 crores plus interest. The bank's appeal is pending. My appeal is also should be pending, but to admit my appeal, they say mandatory deposit. In normal cases where only my appeal is pending, my lords, I can understand that you must insist 40% of. But this is a case where I have gotten counterclaim awarded in my favor where the bank has appealed. There is no stay of the bank so far as those 4 crores are concerned.
DRT Vizag allowed our respondents to recover 8 point
and allowed my 4
crores, deducting 4 crores of the counterclaim.
That's right, Lords. So
the total claim which was awarded to the bank was 13 crores.
That's right. That's
4 is your counterclaim.
That's right.
So they awarded them 8 crores.
That's right. The point is the DRT's order and then I show the DRAT's order. Would your lordship kindly?
You've gone to the High Court, no?
We went to the High Court. The High Court has dismissed my writ, but the order is not out yet.
Where is the order?
The impugned order, it's not uploaded yet. Page 1. Auction is today. My auction is today. That's why we put it in urgency. It's a running factory, my lord. It's an MSME running factory.
Period for confirmation of the auction sale?
It's confirmed.
One minute. Is concerned, my lord, the auction got confirmed. We couldn't come in time. So far as the residential properties are concerned, won't be confirmed. Just kindly see the notice, my lords. The paper publication is for today.
But you've been asked by the DRA to deposit 40% of 13 crores.
That's what I'm saying, my lord. There is no question of 13. Because I have 4 crores counterclaim awarded in my favor. That's number 1. Number 2, would you lordship
8 crores. Suppose we were to say 40% of 8 crores.
There is one more concern there. Would your lordship kindly see the DRT's order? The DRT
Anyway, let's have Mr. Parmeshwar, let's have a look at the High Court's order. Let's see what the High Court has said.
I'm only saying, your lordship says it won't be confirmed.
Why should we
Say
pass
this,
that
only that. Because
We'll keep it on Monday. We'll keep it on Monday. You go to the put the order. If you get a copy of the order, put it on order. Mention it tomorrow. We'll keep it on Friday.
Very well. Very well.
Keep it on Monday.
Otherwise on Monday. Get it.
6.
Lord, 6, Lord. So this is a writ petition, Lord. I represent a body called Save Life Foundation. Save Life Foundation has come to this honorable court even on earlier occasions, Lord. It really relates to the 4 lakh plus injuries and deaths that take place, Lord. Injury-related deaths that take place amongst the highest in the world in our country, because the trauma care scenario is not problematic. Today, Lord, if somebody was to have an accident, let's say on Tilak Marg, he doesn't even know where to go, where to contact. And then the question is, what is the nature of channelization? How is the person going to be shifted? But when many years ago, Lord, I have just see the prayers, please, at page 65.
Yes.
Lord, there are 2 issues. Because not one is, of course, I'm grateful your lordship is kind enough to issue a notice, Lord. Please just see prayer A for a moment. A not is not page 65 at 66.
Establishment of grievance redressal mechanisms.
Yes, Lord. Now this is a
comprehensive this medical rescue protocol.
Yes, Lord. D is what I'm concerned with. Not B on B. Not A and C. D will take time. Lord.
Perhaps what we can do is there is a road safety committee chaired by a former Sapre. we can ask him to prepare a protocol for us and submit
Why
it
not
to us.
I just say this? Not in this case, not just see prayer B.
Yes.
The 134A is already there. So today is not that 134A is not there. The difficulty is not, it's a state subject.
Right.
Because it's a state subject, it's not being acted. That's why we made all of them parties. So not today what I'm seeking is this, Lord. There, if my Lord, if the respondent state can do it within not
Let them come back in 2 weeks. Just
Why
stop
not?
them and come.
well, may I just say this? But the only prayer was that if it could 3 months, because today what's happening is I'll tell your Lordship,
Just come
the
back
law,
after, come back with service in 2 weeks. We'll give you Dusty.
My
And,
lord.
are the states all parties here?
not all the states are parties. Union is a party, states party, the party. Not.
So
I
we
was
give
really
you liberty
concerned
to
on
serve the standing
where we-
council Dusty and come back in 2
yes,
in 2
Lord.
weeks.
And not would your Lordship also consider, Lord, one more thing, Lord, prayer K.
To notice, these are not matters where we have to pass an addendum ex parte order. Let them come here, we'll pass that order. Let the government be here before us.
I'm not. I leave through standing councils then
Yes.
and serve through Senate.
We right? So, yeah.
Deeply obliged. Lord, grateful, Lord, deeply obliged.
With your Lordship's kind permission, may I mention